students. I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. The topic for the day is Constitutional Validity of Right to Privacy in India. So let us begin with it. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They conferred, as against the government, the right to be let alone, the most comprehensive of the rights and the right most valued by civilized men. Justice Brandeis, US Supreme Court. To start up with a simple version, we all know that man is a social animal and he needs the company of others where he can open up his feelings. But how much information is to be shared with others depend upon his own choice. Individuals always want to establish a boundary around themselves so that others must know the arena and the limits in which they have to act and need to intrude in their privacy. Privacy is a state when one wants isolation, seclusion, as well as non-interference by others. Everyone wants that right to privacy must be recognized by the state. But even if it is not so, then it is to be remembered that privacy is an inherent right. Man is born with some natural rights which no one can intrude, and privacy is such a right which runs like shadow with every human being. The utmost need of privacy as a right stems from the changing pattern of society where we are shifting from group to individual. Concept of privacy has gained much more importance in the present scenario due to changing technological and social context. The right of privacy lies at the heart of individual autonomy and no one wants to compromise it at any cost. Though it seems paradoxical, but privacy, which is opposite of freedom, is one of the important aspects which help in growth of individual's freedom. Right of privacy has many dimensions and very frequently it clashes with morality. And because of this clash, we often get remembrance of heart-deviling controversy on privacy and morality. International jurisprudential arena of privacy. Privacy is a way by which we protect ourselves from unnecessary interference of others and even by the state. Right to privacy serves as a base on which edifices of other rights are created. It is worthwhile to mention here that Universal Declaration of Human Rights, which is a milestone document in the history of human rights, has recognized privacy as a basic human right. Article 12 of UDHR states that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attack upon his honor and reputation. Everyone has the right to the protection of law against such interference or attacks. Not only UDHR but various other international instruments have also recognized privacy as an important fundamental right of human being. The International Convention on Civil and Political Rights, the UN Convention on Migrant Workers, and the UN Convention on the Protection of Child are few of them which have specific reference to privacy as a right. Article 8 of the 1950 Convention for the Protection of Human Rights and Fundamental Freedoms state that everyone has the right to respect for his private and family life, his home, his correspondence, and there shall be no interference by a public authority with the exercise of this right except as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or economic well-being of the country, for the prevention of disorder or crime, for the protection of health of morals, or for the protection of rights and freedom of others. The Convention created the European Commission of Human Rights and the European Court of Human Rights to oversee enforcement. Both have been particularly active in enforcement of privacy right and have consistently viewed articles protection expensively and restriction narrowly. The Commission found in its first decision on privacy for numerous Anglo-Saxon and French authors, the right to respect private life is the right to privacy, the right to live as far as one wishes, protected from publicity. In the opinion of Commission, however, right to respect for private life does not end there. It comprises also, to a certain degree, the right to establish and develop relationship with other human beings, especially in the emotional field for the development and fulfillment of one's own personality. United Nations General Assembly Third Committee has also passed a new resolution on the right to privacy in the digital age on November 21, 2016. The resolution recognized the importance of respecting international commitment in relation to the right to privacy. It underscores that any legitimate concern states may have with regard to their security can and should be addressed in a manner consistent with obligation under international human rights law. Constitutional jurisprudence on right to privacy in India. The word privacy has nowhere been defined in the Indian Constitution, but hints and traits can be gathered from the provision of the Constitution itself. Privacy is one word which seems very simple to define, but legally it is a complex concept carrying within itself clusters of rights. Indian Constitution is not static, rather our respected judiciary has always evolved it from time to time. The best example of progressive development of constitutional jurisprudence is Article 21, which has been given the maximum widest interpretation by the Indian courts. Right to privacy has various implications and dimensions which can be correctly made understandable while having a glimpse at the following cases. In MP Sharma and others, in Khadak Singh versus the state of UP, the Supreme Court had the occasion to consider the ambit and scope of right to privacy when the power of surveillance conferred on the police by the provision of UP police regulation came to be challenged as being violative of Article 19 Clause 1 Subclause D and Article 21 of the Constitution. The court repelled the argument of infringement of freedom guaranteed under Article 19 Clause 1 Clause D of the Constitution and pointed out that the right of privacy is not a guaranteed right under our Constitution, and therefore the attempt to ascertain the movements of an individual, which is merely a manner in which privacy is invaded, is not an infringement of a fundamental right guaranteed by Part 3. In Govind versus State of MP, the court stated that the right to privacy in any event will necessarily have to go through a process of case-by-case development. Therefore, even assuming that the right to personal liberty, the right to move freely throughout the territory of India, and the freedom of speech create an independent right of privacy as an emanation from which one can characterize as fundamental right, we do not think that the right is absolute. The court further stated that any right to privacy must encompass and protect the personal intimacies of the home, the family, marriage, motherhood, procreation, and child rearing. This catalog approach to the question is obviously not as instructive as it does not give an identical picture of that distinctive characteristics of the right of privacy. Perhaps only suggestion that can be offered as unifying principle underlying the concept has been the assertion that a claim right must be fundamental right implicit in the concept of ordered liberty. Rights and freedom of citizen are set forth in the Constitution in order to guarantee that the individual, his personality, and those things stemmed with his personality shall be free from official interference, except where a reasonable basis for intrusion exists. Mr. X versus Hospital Z, the court stated, right to privacy has been culled out of the provisions of Article 21. Other provisions of the Constitution relating to fundamental rights read with the directive principle of the state policy. In R. Raja Gopal and another versus State of Tamil Nadu and others, the Supreme Court held the right to privacy is implicit in the right to life and liberty guaranteed to the citizen of this country by Article 21. It is a right to be let alone. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything concerning the above matter without his consent, whether truthful or otherwise, and whether laudatory or critical. If he does so, he would be violating the rights to privacy of the person concerned and would be liable in an action for damages. Position may, however, be different if a person voluntarily thrusts himself into controversy or invites or raises a controversy. In case of PUCL versus Union of India and others, the Supreme Court held that right to privacy is part of right to life and personal liberty enshrined under Article 21 of the Constitution. Once fact in a given case constitutes a right to privacy, Article 21 is attracted. The said right cannot be curtailed except according to procedure established by law. The right to privacy by itself has not been identified under the Constitution. As a concept, it may be too broad and moralistic to define it judicially. Whether right to privacy can be claimed or has been infringed in a given case would depend on the facts of the said cases. After having a glimpse at the above case law, it can be safely concluded that there is no explicit provision of privacy right under the Indian Constitution. Right to privacy has been given a very strict, narrow interpretation in MP Sharma and Khadak Singh case. However, right to privacy has been recognized by the Indian court as part and parcel of Article 21 of the Constitution of India. To recognize privacy as intrinsic feature of Part 3 of the Constitution is the biggest achievement for the citizen of India, which is made possible only by sincere effort of judiciary. Right to Privacy Bill. Though judiciary has recognized the right of privacy, but legislature has still to do its role by giving a statutory support to this right. In this era of information and technology, when everything is becoming then we have to seriously ponder over to protect the privacy of citizens. Since there is no specific legislation in India that deals with the subject of right to privacy, therefore various attempts have been made by legislators to make a law on this subject, but till date the draft of privacy bill have not become a law. Right to privacy bill was drafted in 2011 during the regime of UPA 2 government, but it is hanging in fire since then. On 28 November 2014, the Personal Data Protection Bill was introduced in Rajya Sabha. The objective of introducing this bill is to provide protection to the personal data of individual which is collected by various organizations but is subjected to the risk of being misused. The personal data of individual is usually used for direct marketing purpose without their consent. Because of this, individuals have to face lot of distress and annoyance. Many countries of the world have recognized this right as extension of right to privacy. Therefore, in India, there is a dire need for enacting a law that protects the data information of the individuals. With these objectives, the bill was introduced, but sadly, it could not be turned into reality. Another attempt was made by Mr. Bhaijant Jai Panda, MP, who introduced the Data Privacy and Protection Bill 2017 in Lok Sabha. The main objective was to make right to privacy a fundamental right for the citizen of India. In 2009 also, Mr. B.J. Panda has presented a bill titled The Prevention of Unsolicited Telephonic Call and Protection of Privacy Bill. Other attempts regarding Data Privacy Bill were made by Mr. Rajiv in 2010, Mr. Vivek in 2016 and Mr. Om Prakash Yadav in 2018. In the fifth instance of Data Protection Law, MEITY released the draft of an amended bill known as Data Protection Bill 2022. The bill consisted of total of 6 chapters and 30 sections, which is less in number in comparison with Personal Data Protection Bill 2021. The Digital Personal Data Protection Bill 2023 was introduced in Lok Sabha on 3rd August and it was passed by Lok Sabha on 7th August and by Rajya Sabha on 9th August. The President gave assent on 12th August 2023. The present government of BJP has appointed Mr. B.N. Shri Krishna, former Judge of Supreme Court of India, who will head a committee of experts. The committee will include representatives from the Department of Telecommunications, the IT Ministry, the Unique Identification Authority of India, and the academic community. The purpose of this committee is to suggest strong framework on data protection and issues concerning it. India has Information Technology Law which was enacted in 2000 to deal with the issue of data protection, but it is not a comprehensive law that covers all the problems of the current scenario. A fresh legislation for protecting the data has become the need of hour, and sincere effort on part of government has become utmost important. Currently, we are moving towards extreme digitalization, and therefore our laws must also be up to date. Otherwise, we will face a huge setback. Decision of 9 judge benches of Supreme Court of India on right to privacy in 2017. In August 2017, the Supreme Court of India has created a history in the judicial field by giving a landmark judgment on right to privacy. The Supreme Court, in its verdict, has declared that privacy is not a simple legal right, rather, it falls under the category of fundamental rights. The decision came on petition in regard to Aadhaar filed by Shanta Sinha, Aruna Roy, Dr. Major General S.C. Vomte, and retired Judge of Karnataka High Court, Mr. K.S. Puttaswamy. The main objective behind filing this petition is to challenge the validity of Aadhaar as it violates right to privacy. Though the issue of Aadhaar has yet to be decided, but Supreme Court takes no time to declare that privacy is the core of human dignity. The court has very elaborately discussed the meaning of privacy by giving it an enlarged dimensional view. Justice D.Y. Chandrachud, Justice J.S. Kehar, Justice R.K. Agarwal, and Justice Nazir have expressed their views by stating that there are certain rights which are born with the individual, like right to life and personal liberty, and these are inalienable rights. Right to life and personal liberty has been enshrined in the Indian Constitution under Article 21, but it must be noted that these rights have not been the creation of Constitution, rather these are just recognized by it. And when the judiciary is giving due recognition to right to privacy as a part of Article 21, it is also not creating a new right, because right to privacy is intrinsic and core part of right to life with dignity. Just like a deep ocean which has hidden vast treasure in it which remain under a surface but can be taken only when someone explores it to its depth, similarly, the Indian Constitution has hidden rights like right to privacy which the judiciary has recognized but has not created. Our Constitution contains some precious pearls in form of fundamental right contained under Article 21. The meaning of life has been given widest interpretation so as to give maximum benefit to the citizen and also to the alien. A frozen attitude towards the Constitution is not good because our Constitution is a living law. Due to rapid technological advancement, there is an increasing danger of violation of right to privacy by way of surveillance, profiling, data collection, etc. Earlier, concept of intruding of privacy simply mean that one person is poking nose into other affair. But in the present era, this simplified meaning has been changed to a complex one. Today, it has become necessary to put restriction on power of the government and other private entities so as to secure one's right to privacy. Advancement in technology has permitted various state and non-state actors to enter into premises of any person without asking that person. Therefore, it has become need of the hour to define the area and limit of right to privacy. The consequence of this judgment will be that the state has to meet parameters of the Constitution before entering into parameters of privacy right of any citizen. The scope of judicial review has become more widened with this decision because any act which will try to interfere into the right of privacy has to go through the rigid passage laid down by the judiciary in order to uphold the privacy right of the individual. Right to privacy will without a doubt confine the state meddling, control over the people. The maximum capacity of this correct might be acknowledged by information assurance law that will represent how privately owned business gather and utilize information. Today, the commodification of information and new manipulative advancement utilized by organizations will fuel the difficulty to security. In any case, existing data protection law are as of now inadmissible to handle this test. The judgment should revitalize a discussion on how the present information assurance model should be reevaluated in the light of changing flaw of data security. By proclaiming that privacy is inborn to every single freedom in Part 3 of the Constitution, the Supreme Court has made privacy a basic element of other critical major opportunities, including appropriate to correspondence, free discourse and articulation, religion, and a heap other vital crucial rights, fundamental for a noble presence, subject to sensible limitations of general well-being, ethical quality and request. By declaring right to privacy as a fundamental right, the Supreme Court of India has armed the common man against unnecessary interference by the state and has also extended protection to information privacy in this digital age. Impact of decision of right to privacy on other avenues of law. The above discussed decision of the right to privacy, which is unanimous judgment of 9-judge bench, has opened new chapter for various avenues of law. This biggest impact of the judgment is on the member of LGBT community. This decision has brought certain hope for LGBT people as they were already fighting for their rights, and their hope has been fulfilled by the Supreme Court of India in September 2018 by reversing its own decision of 2013, where it upheld the constitutionality of Section 377 of IPC. The impact of decision of right to privacy given by 9-judge bench acted so strong that Supreme Court held that adult gay sex is not a crime now. If two individuals of same sex indulge in sexual activities in privacy, their privacy has been respected by the Supreme Court of India, which is a commendable effort on its part. The judgment has widened the scope of social arena of the society. It would not be wrong to say that new interpretation given to privacy right has forced the judges to open door for reinterpretation of Section 377 of IPC. The following points will show the implication of the decision of the Supreme Court of India. Right to privacy includes right to choose whether to have food or even medicine. It means now a person has right to decide whether he wants to live or not. Justice Slimeshwar wrote, an individual's right to refuse life-prolonging medical treatment or terminate his life is another freedom which fall within the zone of right to privacy. The Supreme Court's privacy decision may drive cell phone companies to change information security and assure settings. Purchasing on the web leaves electronic impressions that can be amassed to achieve conclusion on the idea of a person's nourishment, dialects, well-being, pastimes, sexual inclination, fellowship, methods for dressing, and so forth. Organization can plunge into their repository of private information on the web-based purchasing to target promoting at people. However, following the protection decision, internet business organizations should stay careful about sharing information when for focusing promotion. The privacy judgment is probably going to set a level of a check against unapproved item fictation of private profiles taken off the web. To an extent, the judgment has also stated that state can govern the eating habits of a person. To put it in other words, it is not the function of state to determine the food habits of a person. Thus, the decision will have an impact of brief imposing order by governments of various states. Since privacy is a complex issue, therefore, this landmark judgment by the court has set at rest various conflicting decisions prevailing before this decision. Though it is not possible to define the area of privacy, but still, Supreme Court has tried to interpret the concept in the widest manner possible. This decision has highlighted the need to enact a comprehensive legislation on privacy on data protection. We can conclude by saying that technology changes and advancement has forced us to think seriously on privacy right. The age of digitalization has made us to be more careful and cautious regarding our privacy matters. Right to privacy include our individual physical privacy along with our informational privacy. Thus, the need at present is to recognize this right and ensure that individual data is protected and cannot be shared without his consent. After the historic version of the Supreme Court of India on right to privacy, now the ball is in the court of parliament. It is now up to the legislature to define the contour of the privacy under ambit of Article 21 of the Indian Constitution. Before codifying right to privacy, it has to be seen by the government that it passes the test of reasonable restrictions imposed by the Constitution. Right to privacy is not a closed-ended right, rather it is a dynamic right. Before enacting a legislation of this right, the government has to give due consideration to concern of intelligence agencies also. A balance has to be created in the individual right and the interest of the state. As Justice Chandrachud has stated, formulation of a regime for data protection is a complex exercise that needs to be undertaken by the state after a careful balancing of requirement of privacy coupled with other values which the protection of data subserves together with the legitimate concern of the state. The declaration of privacy as a fundamental right by Supreme Court is the biggest victory for India, but it is to be remembered that it is only a first step taken by judiciary as a robust regime is to be covered by the government. Thank you and have a nice day.